So the Supreme Court issued a major 6-2 decision which just changed the landscape of agency overreach and is going to have major implications for many agencies like the ATF and their current Second Amendment violations. So let's break down what just happened with this issue. Also want to thank the sponsor of this video, which is Ground News. One of the biggest challenges I face when reading news and going to news sources is the lack of balanced coverage on issues like gun rights. Now, one of the really cool things about Ground News and why I find them super valuable is the fact that Ground News is an app and website that aggregates all related articles around the world, providing context about the sources themselves, including their political leanings. It fact checks them, it gives them a facts rating, and then also other important metrics that help you decide if what you are reading is in fact credible. So if you're interested in Ground News and you want this type of resource, you can check them out using the links down below in the detail section and then also in the pinned comment, or you can simply go to www.groundnews.com/armscholar. And if you go to them and you use my link, you can sign up for less than $1 a month. And then also, if you use that link, you can get 40% off the unlimited access of their Vantage plan, which again just helps you and gives you more resources. You can also use this QR code here on the screen if you're interested. But regardless, thank you to Ground News for sponsoring and supporting this content. As I mentioned in the intro, in this video, we're going to be discussing two important cases which were just decided by the Supreme Court. The Supreme Court has issued two decisions, and these are historic decisions which are going to have broad-reaching implications and is going to impact a lot of issues, including Second Amendment overreach by the agencies like the ATF. The cases we're going to be discussing are Loper Bright Enterprises versus Raimondo, and then also the Relentless case, which is against the U.S. Department of Commerce. These cases use issues over phishing to bring an end to Chevron deference once and for all. And in a 6-2 decision and then also a 6-3 decision, both of these cases by the Supreme Court have been issued and it overruled Chevron once and for all. These decisions are landmark legal precedent which going forward will restrict agencies like the ATF who are trying to broadly interpret statutory text however they want to simply have these courts defer to them and their judgment under Chevron. Now, if you're not aware what Chevron deference refers to, Chevron deference is a term coined after a Supreme Court case, which is the Chevron versus the NRDC decision, and that was issued back in 1984. This case established the concept of courts giving deference to agency interpretations of ambiguous statutory terms and text that Congress has essentially tasked that agency with implementing. The argument under Chevron is that when a statute is ambiguous or silent in some way on some issue, the agency responsible for enforcing that statute may be able to determine what Congress intended as long as their interpretation was deemed rational or reasonable by a court. Now, in contrast to Chevron deference, there are other canons of construction and essentially interpretation that courts could use. They could use things like the rule of lenity, which indicates that when dealing with criminal statutory interpretations, any unclear or ambiguous statute or term text could in fact be interpreted in a way that is more favorable to the people, not the enforcement agency like the ATF. There are other concepts like the major question doctrine, which the Supreme Court recently used last year, I believe, in the West Virginia versus EPA case, and then also they used in a different case which dealt with student loans. Now, since 2016, the Supreme Court has moved away from using Chevron and has tried to limit it and kind of put restrictions on it, but you've seen a lot of lower courts still exclusively rely on Chevron, and so it was time for the Supreme Court to finally address whether or not they were going to overrule Chevron altogether or put very, very significant restrictions on it. And ultimately what they decided was to do away with Chevron once and for all. Now, the facts surrounding this case which led to this decision are as follows. Loper Bright Enterprises is a family-owned herring fishing company that operates out of New England. Now, on these very small boats, every inch of space is very important. However, in the herring industry, there was a new rule that came out of the National Marine Fisheries Services, or the NMFS. This new regulation required that the herring fishing boats were going to be required to have an additional person on board to serve as a monitor. The rule required this additional monitor so that the boats could be in compliance with their tracking compliance, and essentially that was going to be required under federal regulations. Not only does that additional person on the boat take up space, but then the boats themselves were going to be required to pay that monitor's salary, which was an estimated $700 per day. So not only was it going to take up space, but it was going to cost every single boat a lot of money, and it would cut into their profits. Loper Bright Enterprises and other fisheries sued and challenged this rule, arguing that the NMFS lacks statutory authority to force them to pay for these monitors. And it's this issue about fishing and statutory interpretation to require these monitors. It's that issue that went up to the Supreme Court. Now, the big question in front of the Supreme Court was whether or not to overhaul Chevron altogether, or at the very least put very significant limitations on the ability of an agency to use Chevron when a statute is silent on an issue. Now, also, there was a different case called the Relentless case that dealt with the very same issue that was consolidated also with the LBE case. So there was two cases, two decisions that were issued by the Supreme Court. Now, in a 6-2 decision, authored by Chief Justice Roberts, the court has overruled Chevron entirely. So that is a huge win. The majority opinion was authored by Roberts, and it was joined by Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. The dissent was Kagan and Sotomayor. Now, in this LBE case, Justice Jackson had to recuse herself, so that's why you have this very weird 6-2 decision. But then in the Relentless case, which again was consolidated and plays simply off this same issue, that's where you have the 6-3 decision, because Justice Jackson also served in the dissent. Now, in the decision of the court, they state that the Administrative Procedures Act requires a court to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts may not defer to an agency's interpretation of the law simply because a statute is ambiguous. And then they state Chevron is overruled. The court goes on to state that the deference that Chevron requires of courts reviewing agency actions cannot be squared with the Administrative Procedures Act. They stated that one of the big issues after Chevron was that all the lower courts following Chevron then kind of expanded it and found that whenever there was an ambiguity or silence on any of these issues, courts would just automatically just defer to whatever the agency said. And they said that caused a lot of issues, and that was never what the framers intended when, of course, they structured our government. They state that perhaps most fundamentally, Chevron's presumption is misguided because agencies have no special competence in resolving statutory ambiguities. Courts do. The framers anticipated that courts would often confront statutory ambiguities and expect that courts would resolve them by exercising independent legal judgment. Chevron gravely erred in concluding that the inquiry is fundamentally different just because an administrative interpretation is in play. Delegating ultimate interpretive authority to agencies is simply not necessary to ensure that the resolution of statutory ambiguities is well informed by subject matter expertise. Chevron has proved to be fundamentally misguided. It reshaped judicial review of agency action without grappling with the APA, the statute that lays out how such review works, and its flaws were apparent from the start, prompting the court to revise its foundations and continually limit its application. Experience has shown that Chevron is unworkable. The defining feature of the framework is the identification of statutory ambiguity, but the concept of ambiguity has always evaded meaningful definition. Such an impressionistic and malleable concept cannot stand as an everyday test for allocating interpretive authority between courts and agencies. The court has also been forced to clarify the doctrine again and again, only adding to Chevron's unworkability, and the doctrine continues to spawn difficult threshold questions that promise to further complicate the inquiry should Chevron be retained. And based on all of that, the court has found Chevron is unworkable, it should have never existed, and therefore they overruled Chevron altogether. Now, this again was a big decision and goes a very long way to rein in federal regulatory agencies and their overreach. And this involves many areas, not just when it comes to firearms and the Second Amendment and the ATF. This is going to impact the EPA, the FDA, the FFA, the FAA, and a lot of other agencies as well. So keep in mind, the ATF did kind of see the writing on the wall when it came to all this stuff. They started to move away in some ways from exclusively kind of relying on Chevron. So for example, a good example of that would be the Cargill case, where they stated that under the plain text of the GCA, they believe that the statutory term and definition of a machine gun did in fact include items like bump stocks. So they said based on the express text, bump stocks were machine guns. But then later on in that same brief, they would say that, okay, if the court found that the term machine gun was ambiguous in some way, well, then the court should simply just rely on Chevron and defer to the agency's interpretation that they believed bump stocks were machine guns. So you can see, as in some of these cases, the ATF was not exclusively relying on Chevron. They saw the writing on the wall, so they tried to move away from it. But still, this goes a very long way to reining in agency overreach and just completely does away with this backstop that agencies had for a very long time. So again, this decision is going to go a long way if you're a fan of reining in federal regulations and reining in agency overreach. This is a huge decision and is going to impact a lot of things. And I'm very excited to see this decision. Awesome news. I know a lot of people are excited for this decision. I wanted to cover it when it first hit, but unfortunately I was out in Iowa, doing the gun con thing. Again, amazing event. I got to speak on the 2A panel with a bunch of other people, and then also got to speak on the elite panel. It was a lot of fun, but again, we didn't have great reception, so I couldn't cover this. Thank you guys so much for all your support. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.